In this lecture, I want to focus on the implementation of two specific Supreme Court decisions and try to compare and contrast them. And those two decisions are Brown v. Board of Education and Miranda v. Arizona. Brown v. Board of Education, of course, was the decision in which the Supreme Court said that the Equal Protection Clause prohibited segregated schools and that schools must be desegregated on a racial basis. The Miranda decision, of course, was the case in which police officers were forced to read suspects their rights when they are arrested. Now, both of these decisions generated significant opposition. The Brown v. Board of Education decision, in fact, generated some of the most intense opposition of any Supreme Court decision of all time, and that was encapsulated by something known as the Southern Manifesto. Following the Brown decision, Southern politicians were pressured to sign the Southern Manifesto, which was essentially a declaration of legal war and legal resistance to the Supreme Court's decision, calling it out and saying it was wrong. And literally hundreds of Southern politicians signed the Southern Manifesto, and that actually came up in your reading of the Rehnquist choice. But the Southern Manifesto, again, was a declaration of war. We regard the decisions of the Supreme Court in the school cases as a clear abuse of judicial power. In the case of Plessy v. Ferguson in 1896, the Supreme Court expressly declared that under the 14th Amendment, no person was denied any of his rights if the states provided separate but equal facilities. This decision has been followed in many other cases. Though there's been no constitutional amendment or act of Congress changing this established legal principle almost a century old, the Supreme Court of the United States, with no legal basis for such action, undertook to exercise their naked judicial power and substituted their personal, political, and social ideas for the established law of the land. We decry the Supreme Court's encroachment on the rights reserved to the states and to the people, contrary to established law and to the Constitution. We commend the motives of those states which have declared the intention to resist forced integration by any lawful means. And so the South said, we are not going to do it. Now, the interesting thing is, again, Southern school districts strongly opposed the Brown v. Board of Education decision. But you know what? Police officers also strongly opposed the Miranda decision. They felt that if they were forced to read suspects their rights, that they would get fewer confessions and that fewer crimes would be solved. And so in both cases, the implementing population was strongly opposed to the decision. And yet, the response was a little bit different in that Brown v. Board of Education was widely evaded. It was met with massive resistance, as you know, National Guards being brought out and so on and so forth, and it led to, of course, a whole decade or more than a decade of turmoil and resistance as Southern states tried to keep the status quo. Miranda, on the other hand, was in fact initially opposed by police officers, but relatively quickly it gained acceptance, and in fact, today it's an ingrained practice in most police departments. And in fact, there was a survey conducted several years after the Miranda decision, and most police departments said that even if Miranda was overturned, they would still continue the practice of reading suspects their rights. So it's an interesting question. Why was the response to Brown so much more vociferous and long-standing than the opposition to Miranda? Well, political theorists and political scientists have come up with various theories for why some Supreme Court decisions are met with relative acceptance, whereas others are widely evaded. And so let's take a look at a couple of those theories. One of these theories is known as Cost-Benefit Theory. And Cost-Benefit Theory is a theory that, of course, is taken from the discipline of economics. And it argues simply that people make decisions based on the costs and the benefits. And I don't think anybody could probably argue with this. That they decide what's the cost of an action, what's the benefit of an action, and if the cost of complying with a Supreme Court decision outweighs the cost of evading a Supreme Court decision, then evasion is probably likely. That makes sense. If it's going to take you a lot of time, effort, or money to comply with a Supreme Court decision, then you're probably going to be less likely to do it than if it's easy to comply with. And of course, the opposite is also true. If the costs of evading a decision outweigh the costs of complying with it, well, then compliance is likely. This is the way we make almost every decision. So what costs might we be talking about? Because costs certainly might be monetary, but they go beyond that. But certainly monetary costs. And so one explanation as to why Brown v. Board of Education was more widely evaded than the Miranda decision was partially because it was simply much less costly in terms of money to implement the Miranda decision. In fact, it cost nothing at all in terms of money. Police officers just needed a little bit of training, and then they would read the Miranda warning. Of course, the desegregation of schools after Brown v. Board of Education was extremely costly, ultimately involving busing, so there was the need to purchase buses, develop new plans, perhaps even build new schools, and as a result, the monetary cost of complying with Brown was significantly higher than it was with Miranda. But, of course, money is not the only kind of cost. Another kind of cost is the amount of effort involved. Something that takes a lot of effort is going to get fewer people doing it than something that's easy to do. And of course, this is another explanation for why Miranda was so much more easily implemented. It didn't take very much. Most police officers were given a card that they could just read until they had it memorized. So implementing the Miranda decision was extremely easy. Obviously, implementing Brown v. Board of Education was extremely difficult. Trying to assign students to new schools and get them there, and it basically involved redesigning the entire educational system, and as a result, that was another extremely high cost. And of course, there are psychological costs as well, and these could be among the most important. One of those is simply, do you agree with the decision? If you agree with the decision, then of course you're going to be very likely to implement it because there's no psychological cost for doing so. You already agree with it. In fact, you get a psychological benefit for complying with the decision. So let's say, for example, you're a teacher who's an atheist, and all of a sudden the Supreme Court says that you can't pray in school. Well, if you're an atheist, you didn't want to lead your students in prayer anyway. So now that the Supreme Court is saying you can't, of course you're going to comply with that decision because it's what you wanted in the first place. On the other hand, if you're a deeply religious teacher and you're told not to lead your students in prayer, then the psychological cost is very, very high, and you're going to be more likely to evade the court's decision. So the psychological costs are high. And again, this is a good explanation for why the Brown decision was so much harder to implement than the Miranda decision. Psychologically, the price for white racists and white Southerners to integrate the schools was extremely high for them. The thought of black and white children going to the same schools, dating each other, was extremely frightening and threatening to most Southern whites. And as a result, the psychological cost extremely high. Miranda, the psychological cost very low. Police officers didn't want to read the Miranda warning, but they didn't take it as a personal attack or anything like that. And so in all three instances, the cost of complying with the Miranda decision much lower than the cost of compliance with Brown. So among the psychological costs that individuals have is not only their own beliefs, whether they oppose or support the decision, but also it's the attitudes of other people around them. If individuals want to comply with the decision, but all of the people around them don't want to comply with the decision, then they will be under significant pressure not to comply. So it's not just their own beliefs, but it's also the beliefs of the people in their immediate environment. And there's actually a really interesting book that was written about the attempt to desegregate the schools after Brown v. Board of Education. It's called 53 Lonely Men. And the 53 lonely men in this case were the United States District Court judges who were responsible for overseeing the desegregation plans in the South. They were lonely men because they were doing things and they were forcing the South to do things that most people in the South absolutely did not want to do. And in fact, it was very important for them to be federal judges rather than state judges, because state judges would probably be too likely to be influenced by other state actors. The 53 federal judges had lifetime appointments, so they couldn't be removed, and they saw their task through, but of course they didn't win themselves any friends along the way. There's another set of theories that tries to explain compliance with Supreme Court decisions or evasion with Supreme Court decisions, and that's called Principal-Agent Theory. Principal-Agent Theory. In principal-agent theories, agents work for principals. So principal is kind of like the boss, and an agent is their subordinate, although it's not necessarily an employment relationship. Of course, if you're selling your house, you would hire a real estate agent to work on your behalf. So you would be the principal and they would be the agent. So we find principals and agents in all kinds of places. And of course, principals always want their agents to enact the principal's will. When you hire an agent, if you hire a real estate agent, you want them to work for your benefit on your behalf. You don't want the agent to work on their own behalf. But agents, of course, want to what we call shirk. Agents want to get paid. Agents want they want the benefits of agency, but they really would prefer to shirk. What does shirking mean? Well, in many cases it means simply not doing the work at all. So you understand this. If you are in a company and your boss is gone on a Friday, you might take off a little bit early if the boss is never going to know about it. So sometimes agents simply don't want to do the work that they've been assigned. In other instances, they'll do the work, but they want the outcomes to benefit them rather than to benefit the agent, to benefit the principal. And so sometimes agents will pursue their own agendas. And when we talk about principal-agent theory in the context of the courts, of course, the principal is the Supreme Court. It hands down a decision that says this is what it must be done, but then it's the lower courts and the implementing population that act as their agents that are supposed to carry it out, and yet many times those agents don't want to do that. And as a result, Principal-Agent Theory says that principals have to monitor their agents closely. So bosses should monitor their workers, you should monitor your real estate agent, and you should keep a close eye on them in order to make sure that they're actually doing the work that they're supposed to do and that they're actually benefiting you, the principal, rather than themselves, the agent. The only problem is, it's very, very hard for the United States Supreme Court to monitor the decisions that are made by lower courts. There are thousands of such decisions, and of course we've already seen that the court only decides about 70 or 75 cases every year. So the fact of the matter is, if there is a lower court that is simply not implementing a Supreme Court decision, or if there's a government agency that isn't implementing it or opposing a Supreme Court decision, it's very likely that the Supreme Court will never even know about it. And of course, it only hears about these things if those cases are appealed. The Supreme Court has no procedure by which it monitors the ongoing implementation of its decisions. So it has to rely on other people to bring these things to its attention, and of course its attention is extremely limited. In addition, they really don't have very many good ways to punish people who don't obey their mandates. They can't fire lower court judges, they can't fire governors, they can't fire state legislators. The only sanction that they have typically is the ability to reverse a lower court decision, and then they have to hope that their new decision is faithfully implemented. But of course, if the first decision wasn't faithfully implemented, it's possible that the next one won't be implemented, and then you'd have to wait for another appeal. So in fact, under principal agent theory, the Supreme Court has very little power to monitor what's going on with the lower courts. And of course, not only can they not fire lower court judges, they can't reduce their pay. And so, under principal agent theory, the question is, what factors can a principal employ to increase compliance on behalf of their agent? So principal agent theory has some predictions about when compliance with Supreme Court decisions will be more likely. And one of those is that compliance, of course, should be higher when the likelihood of an appeal is higher. If the court doesn't have the chance to supervise a decision, then clearly that the lower courts are going to have more chance to evade it. But if there's a higher chance that the case will come to the Supreme Court's attention, then of course the lower court will be more likely to pay attention to what the Supreme Court wants. And what that means is Supreme Court decisions that are more specific should be more likely to be appealed and therefore more likely to be followed than decisions that are vague. And this is definitely true when it comes to Miranda and when it comes to Brown v. Board of Education. With regard to Miranda, it was very specific. In fact, the Supreme Court essentially told police officers what they needed to tell suspects. You have the right to remain silent, so on and so forth. Extremely specific. Brown, on the other hand, was not at all specific. And in fact, that was by design. You'll recall that earlier in the semester we talked about Earl Warren wanting to get a unanimous decision in Brown v. Board of Education, and in fact he did get it. Well, how did he get that? Well, he got that by making certain concessions. And one of those was the fact that Brown was actually decided over 2 years. There are two Brown cases. Brown 1, which is the very famous case that we're familiar with, and then there's Brown 2 that was decided the next year. Brown 1 said that segregated schools were unconstitutional. Brown 2 dealt with what are we going to do about it? How are we going to fix this situation? And Brown 2 was extremely unclear because of Warren's desire to get a unanimous court. He said in Brown 2, he used a very famous phrase. He said that states should deliberate and that school districts should integrate with all deliberate speed. With all deliberate speed. Now this is a very ambiguous phrase in that the deliberate suggests a amount of slowness, and speed, of course, suggests quickness. And of course, what they were suggesting here was that the states and school districts should move quickly but deliberately. So they shouldn't just do it without thinking, but they should think about it and then proceed. And of course, Warren thought that and hoped that they would emphasize the speed. But of course, the school districts tended to emphasize the deliberate part by doing the bare minimum they felt they could get away with under the law, waiting for another lawsuit, and then doing the bare minimum they felt they needed to do after the next lawsuit, just dragging their heels as much as they possibly could. And so finally, 10 years after Brown v. Board of Education, in another case, the court simply said the time for mere deliberate speed has run out. They said we want schools to be integrated now. So even the court here recognized that its ambiguity and its lack of clarity and specificity was one of the things that undermined compliance with its decision. Another prediction from principal agent theory is that compliance should be higher when the Supreme Court is very consistent in its message. If the court is wishy-washy, and in fact, if it suggests that it itself is about to reverse itself, then of course lower courts should be less likely to comply with the Supreme Court precedent than if the court is sending a very, very clear signal that it sticks by the precedent. court sends signals over time as to whether they agree with a precedent or disagree with a precedent, whether they're thinking about overturning it or not. You've seen some examples of this in the oath. And under principal agent theory, if the court has indicated in some way that they're not certain about the course of action they're taking, then of course the lower courts will be more likely to evade. And one way that people look at this is they say that unanimous decisions of the court, or 8-1 decisions of the Supreme Court, should engender more compliance than 5-4 decisions. 5-4 decisions, of course, indicate that the court is closely divided, and if one justice leaves the court or if one justice changes their mind, it's entirely possible that the court will go in the other direction. A unanimous decision, of course, means that all 9 justices agree, and it's going to be a long time before the court reverses itself. And in fact, Earl Warren was implicitly endorsing this theory when he tried to get a unanimous court. Now, as political scientists have investigated this, there doesn't really seem to be a whole lot of empirical support for this. So the data do not suggest, as far as we can tell, that unanimous decisions are more likely to be followed, but nevertheless, that's one of the predictions. Now finally, just in general, there's a third theory regarding Supreme Court compliance, and that is legitimacy theory. And that is simply the fact, and this runs through the entire semester, of course, we've continually talked about the court's attempts to maintain the fiction or the aura of legitimacy, that it is a legal institution rather than a political institution. And that's because they embrace legitimacy theory. They believe that the more that individuals perceive the Supreme Court to be legitimate, the more likely they'll be to comply with the court's decisions. You may not like a law, but if you feel that the government has the right to implement it, then you are more likely to follow it than if you don't feel the government has the right to implement it. And one real problem that all observers of the court have noted is that respect for the Supreme Court has been declining over the last couple of decades. Now, it is true, the respect for the Supreme Court is significantly higher among Americans than it is for either the Congress or the presidency, but the respect for the court has been declining. And here are some data. We'll take a look at another chart in a moment, but here's some longitudinal data taken from the Pew Research Center. And as you can tell, the long-term trend is a decline in support for the court between 1985 and 2012. Obviously, things bounced around from individual years, but the overall trend is a decline. And as we can see from this chart from the 21st century, things haven't gotten any better, with only slightly more than half of the American public approving of the way the Supreme Court handles its job. But in a worrisome trend, of course, the partisan gap in perceptions of the Supreme Court is at an all-time high, and this shouldn't surprise us. America and Washington, D.C. have both become highly partisan, highly polarized, and so it shouldn't surprise us that we see this gap in support for the Supreme Court as well. And in fact, much of the increase in support for the court has come from Republicans during the Trump administration. And it's interesting, of course, the moment Donald Trump became president, support for the Supreme Court tended to increase among Republicans. So to the extent it's clear that the court is a partisan institution, it's seen that way by many Americans, and this ultimately must be worrisome for Chief Justice Roberts and anybody who's concerned about compliance with court decisions.